Corin Misano, the presiding judge for administration for the appellate division. And I want to introduce the members of our first panel, which with a nod to Dickens, we might call jury selection past, present, and yet to come. The man on my far right has had a report named after him. He is Joe Lisa. Judge Lisa is retired and on recall right now to the appellate division. He sat with our court from 2001 to 2011. Prior to that, beginning in 1991, Judge Lisa served as in the civil and criminal parts in the Gloucester, Salem, Cumberland vicinage and was the presiding judge for the criminal part in that vicinage. He served on many capacities, both before and after his retirement. Of course, the Lisa report, which he's going to be speaking about in 2005. And he's a graduate of the University of Pennsylvania and Georgetown Law School. And Judge Lisa will be speaking about jury selection practice in New Jersey with some historical perspective. Next to Judge Lisa, we have Judge Lisa Thornton. Judge Thornton has been the assignment judge of the Monmouth vicinage since 2014. Prior to that, she was presiding judge at family part in that vicinage. Before her appointment to the bench in 2008, Judge Thornton served as chief of staff to the Department of Law and Public Safety, overseeing a department of approximately 9,000 employees. She was senior counsel to Governor John Corzine, and prior to that, special deputy commissioner for the Department of Banking and Insurance. Judge Thornton has also served as a municipal court judge in Neptune Township and was senior trial counsel at Prudential Financial Services. She's a graduate of Douglas College and Rutgers Law School, and she will speak on current jury selection practice in our trial courts. And to my immediate right is Joseph E. Krikora. Judge Joe Krikora has served as the state's public defender since 2011. He's currently in his second 5-year term. Mr. Krikora joined OPD in 1986. He has held numerous positions in that office, including staff attorney and manager in the very busy Essex region. He directed OPD's capital litigation department for many years. He's tried many capital murder cases, and it's fair to say that he has rightly earned a reputation as one of the state's foremost criminal defense attorneys. He has served on the Criminal Disposition and Sentencing Commission, has worked to implement its recommendations, and of course, his office was instrumental in implementing the Criminal Justice Reform Act. Mr. Krikora is a graduate of Princeton University and Cornell University School of Law, and he will speak on the subject of jury selection, perhaps yet to come. Before I turn to Judge Lisa, I do want to say that Judge Lisa and Judge Thornton will be speaking for about 10 minutes each. Joe Krikora, in line with the fact that criminal defense lawyers have 20 peremptory challenges for most cases, will be speaking for 20 minutes. And he does have only appropriate. He does have some video presentations which he'll be making during the course of that. Judge Lisa.
Thank you, Judge Misano. First of all, we're not this tall. They have these chairs up high, I guess, so we don't disappear behind the front here. After hearing the very eloquent and actually inspiring talks we just heard from the Chief Justice and Professor Glaude, I feel kind of bad that I'm going to talk about nuts and bolts stuff like court rules and things. But I guess these court rules and other protocols and processes and structures we build into our system from the bottom up, hopefully we'll get it as close as we can to the goal that we all seek, and that is a truly fair and just system of justice. I'm here because I chaired this committee, and I'm supposed to give a little historical background. This is the report. This is what it looks like in person, not online. The report that we filed in 2005 after about a year or so of work with the committee, which included Mr. Krikora, by the way, one of our distinguished members of that committee. Before I get into that, though, I just want to touch briefly on what got us up to that point in 2004 when the committee was established and why there was a perceived need for a committee to make some recommendations and do some work on the subject. The subject, incidentally, was not just voir dire, but voir dire and peremptory challenges. That was our charge from the Supreme Court. And I think the point of reference for that goes back to 1969 when the court decided State versus Manley, which, as I'm sure most of you know, radically changed the jury selection procedures in New Jersey. Prior to that time, it was a lawyer-driven process. They dominated it. They asked the questions almost exclusively, if not exclusively, in many courtrooms. The court rules in effect at that time merely provided that prospective jurors may, in the discretion of the court, be asked questions. Didn't say by whom, but if the court was exercising discretion, I assume that means somebody other than a judge. The corresponding statute said basically the same thing, but added a few extra phrases saying that the questioning would be subject to the control of the court. So obviously that was referring to controlling what the lawyers would ask. In Manley, this was a routine case that went up on appeal. Mr. Manley was convicted of murder. He had two arguments on appeal. One was a Miranda issue, and the other was actually a voir dire issue. The court readily disposed of those two issues and found no reversible error in either of them and affirmed his conviction. The court then went on to add a long part, the longest part of the opinion, to deal with the voir dire generally. And the court, first of all, noted that historically, and these are words from the court, historically, throughout the country, this wasn't only a New Jersey issue, throughout the country, the feeling was that courts could and would assert a close control over questioning by attorneys of prospective jurors. Unfortunately, the court went on here, as elsewhere, performance has not matched intention, and the interrogation has gotten out of hand. The court then went through a long discussion of what the abuses were. I don't have time to talk about them now, but they're all there in the opinion. And the court said very few judges showed any inclination to control either the length or content of the interrogation that was really improper, geared more to finding partial jurors than impartial jurors. The court announced in that opinion that it was promulgating a new rule, Rule 1:8-3A, which is still in the books today in exactly the same language that they promulgated it then in 1969, minus the deletion of the capital trials part, which no longer applies in New Jersey. And in their opinion, in laying out the text of this new rule, which they said would go into effect 3 months afterwards, they emphasized, they italicized for emphasis two words in that rule. That's not in your rule book, but in the opinion, that's the way they did it. Those two words were shall and may, because the first sentence, as you know, of that rule says that the judge shall interrogate prospective jurors for the purpose of and whatever. The second sentence then says, in the discretion of the court may allow attorneys supplemental opportunity to supplement with questions of their own. And they wanted to make it clear that this is what they were doing, shifting it from a lawyer-driven process to a judge-driven process. The court noted what the purpose of the questioning was and said that the purpose of this questioning by whomever is to provide an expedient, that's their word, an expedient selection of a fair and impartial jury. The court, in its concluding paragraph, really laid out what they intended with this new rule and basically gave an interpretation of the rule that was pretty clear. I'll just pull out a few phrases, but you can read the whole thing. They said judges must exercise considerable restraint in allowing the use of attorney questioning in the voir dire. They said the basic intent of the new rule is to have the voir dire conducted exclusively through the trial judge to the extent reasonably possible. And finally, on this subject, they said, supplementary questioning by counsel is not foreclosed entirely, but it must be considered in the court's discretion with a guarded exercise of discretion. So they were really constricting the discretion that judges should apply in a very tight way to limit or even prohibit lawyer questioning, and the judges were to take it over. Now, in the years that followed and the decades that followed, trial judges were doing what those prescriptions seemed to require. As the years went by, maybe immediately, it just so happens I was admitted to practice in 1969, within 1 month of when Manley was decided. So I missed all of the pre-Manley time. The jury selection process got very truncated, very perfunctory in many courtrooms. Not all. Many judges continued as they had been, doing very thorough and effective voir dires and selecting juries that they could rely on to be fair and impartial. Many others, however, saw this as a way of expedience, speed it up. I have control. I have my 16 questions that I'm going to pose to the whole room full of people. And then when you come up one by one, you know, as you're seated, I'll ask you if you agree with those or if you would say anything differently or whatever the procedure was. And juries were being picked in a pretty perfunctory manner in many courtrooms. There were several reports before our committee was formed in 2004. I won't go through them, but there are at least 3 that I know of. One in 1993, another in 1997, and another in 2003. But all of those addressed only the number of peremptories, and really in criminal trials. That's where the big problem is. That's where the big numbers are. And didn't really address any proposals that would improve the voir dire, because these two things have an inverse relationship. As the voir dire gets better, the need for peremptories is lower, and vice versa. So none of those reports generated any action. The court decided in the early 2000s that it was time to revisit this issue, and they created this special committee made up of judges from all over the state with vast experience in jury trials, both as judges and in their prior life as lawyers, and lawyers with the same experience in trying many civil cases and criminal cases. We had people from both disciplines. And each lawyer on the committee also represented an important constituency in the state. For example, Mr. Kokora, the Office of Public Defender. We had the state bar represented. We had the criminal defense lawyers represented, the County Prosecutors Association, civil bar groups, ATLA, as it was then called, was there. You know, so we had representation from all constituencies, so to speak. And I must tell you, it was a terrific group. Everybody there was there with the right attitude and the right intentions, and did a diligent and very professional job working on these. We decided right at the beginning, and this was a consensus decision that we all shared, judges and lawyers alike, that we had to work on the voir dire piece first. If we couldn't come up with recommendations for concrete changes, not just platitudes and not just goals and not just ideas, but actual changes in the jury selection process that would be beneficial and address some of the concerns that lawyers rightfully had about the way it had been conducted in a lot of courtrooms. And that's all we worked on. If we couldn't get that done, there was no sense in addressing peremptories, because any suggestion to reduce the numbers would go nowhere. So we worked on those. We had subcommittees for civil and criminal. I can't go into all the details. It's in the report, and that's in your materials, by the way. If you haven't read it, it's good reading. I suggest you read it. But in any event, we ended up with 10 recommendations. The first 7 had nothing to do with peremptories. The first 7, and the first of those 7, number 1, I think is really the centerpiece of our work and of our report, and that was the creation, subject to the court's approval naturally, of a set of jury selection standards. These standards explained a new way of doing jury selection with some flexibility built in, but a new way of doing it, which was going to take much longer. By the way, our report wasn't to shorten. We acknowledged that we were not going to be shortening the process. We were going to be lengthening it because the voir dire was going to take longer doing it the way we were recommending. That we had standard questions that were mandatory, a set for civil, a set for criminal. They had to be asked in every case as a baseline. And it had to be certain that each juror was asked directly, or a procedure was set up where each juror knew what they were answering and what they were talking about, not what they might have heard or might not have heard some other juror respond to a half an hour or whatever time earlier. So that was the basic part. The other standards, one was to allow lawyers to propose in writing at or before the pre-voir dire conference written questions that they were requesting the judge to ask, and we encourage liberal use of them. They had to be discussed on the record. Much of this used to be done, if it was done at all, in chambers off the record, but they had to be discussed on the record, and the judge had to rule on them on the record. See if there's any opposition, if they, what the issue is, and decide it on the record. Likewise, with we also did the same thing with supplemental questioning by lawyers. We really turned the tide, maybe not in any dramatic fashion, but that's what we did with that point. We took the Manley prescription of it's not totally eliminated, but exercise discretion in a very guarded manner and strictly enforce it. And we said that if requested, this is the words we used, if requested, at least some lawyer questioning should be permitted. Now, we put in the if requested because the experience of all of us on the committee and was that there weren't that many requests. I mean, let's face it, it was 40 years or so, or it was 50 years, I lose track of, since Manley, and a lot of lawyers came along after Manley and never experienced asking questions. So there wasn't that much of an outroar for it, or uproar for it. But we did say if requested, because we knew that there was a feeling that you should be allowed to, there should be some discretion, then let them ask some questions. And the one other thing we did was to provide that challenges for cause should be liberally granted. It was a practice in many courtrooms that they were kind of not granted too liberally, with the theory that either expressly or implicitly, you've got plenty of peremptories, do whatever you want, but it's a close case. I'm not going to grant a cause excusal. We said that should be the other way around. If it's a close case, grant it, be liberal with them. So those were a couple of retrenchments in the direction against what had been going on in the post-Manley era. So rather than this considerable restraint, guarded exercise of discretion, we were trying to open it up and give the attorneys more power, more of a role, and set up a system of jury selection that was going to be more probing. And so we made the first 7 recommendations. That was the first one, the set of jury selection standards. Now, I can't go through everything. The others dealt with, I'll just highlight a couple of points. One was to establish a standing committee on jury selection in both civil and criminal as a separate standing committee. These next steps were to ensure that if the court approved these standards, that there would be a mechanism and a forum for continuing this process, improving the process with time and experience, and having participation, as we did on the original committee, with lawyers and judges working together, an open process. So standing committee, one of its first tasks would be, this was another recommendation, to develop a manual on jury selection to be used by lawyers and judges alike. So everybody's working out of the same book, and it says here you have to do this, and it says here you can't do this, and you're supposed to do this. Whatever it is, it would be in a manual that everybody would share, and this committee could continue updating it. And that manual was done during the under the standing committee, which I also chaired. I don't know if I said that, and until I retired, that is, and it was approved by the court. We also recommended creating programs for training of judges and for training of lawyers. I participated in a number of those training sessions too. Those first 7 were all approved by the court. The court, I think, I don't speak for the court, but I think they were receptive to considering the recommendations, not necessarily the precise numbers we recommended, but considering some reduction. But under our system in New Jersey, this is something which historically has been done both by court rule and by statute. Whether it has to be that way, I'm not sure, but nobody wanted to find out. The legislature was not willing to consider it. And here's what happened with the peremptories in my closing 2 minutes. Civil was easy. In 1973, we went from 12-member civil juries to 6-member juries. But the number of peremptory challenges pre-1973 was 6, and nobody bothered cutting that in half or changing it at all. The civil practitioners on the committee did not put up a fuss. They thought reducing it to 4, the consensus was really 3 would be the right number. But they persuaded us 4 would be nicer, and we recommended 4 per party. Without opposition, no dissenting report. On the criminal side, both the Office of Public Defender and the Criminal Defense Lawyers Association were vehemently opposed to any reduction at all. I posed the question at one of our meetings, even if we said reduce it from 20 to 19, nothing. They would agree to nothing, and that was fine. That was their position. The committee, however, as the committee of a whole, voted to reduce the number in criminal for all trials, all criminal trials, to be 8 for the defense and 6 for the prosecution. Prosecutors wanted them to be even, and they filed a partial dissent on just that. They endorsed the reduction to whatever number would be agreed upon, but they felt like they should have an equal number, and that's a debatable point. We don't have time to get into that now. As I said, the legislature was not amenable to doing this. There were some rumblings among bar groups, among attorneys, that how do we know these other things are really going to be implemented and enforced and perpetuated, or is this just another report with some ideas in it? And, I think it was implemented over a lot of pushback from a lot of judges. It was implemented and it's been enforced, and I think it creates a basis, a building block where some further improvement can certainly be added to it. That's it. Thank you.
Judge Thornton, you can hit Judge Lisa for taking
I will not do
minutes.
that.
Go ahead.
So I'd like to start out, Judge Manzano, by reading a passage from State versus Andujar. The chief wrote, "The criminal justice system rests on having cases decided by impartial jurors who are drawn from a representative cross-section of the community and selected free from discrimination." So in 8 minutes or less, I want to try to distill the process by which us in the trial courts go about doing that every week. Every week, the judges and the saint-like staff in the jury office summons about hundreds or thousands of people every week in an effort to sit 14 to 16 jurors in a criminal trial. I want to talk very briefly about the composition of the jury pools, pre-reporting process, panel size calculations, and examination of jurors during voir dire. Composition of jury pools. I think that if our goal is to have more inclusive and diverse jury pools, I think the secret sauce in many ways is looking at the statute 2B20-2 and 2B20-4 for the source list. Jurors are drawn from lists from registered voters, filers of income tax returns, homestead rebate applications, and licensed drivers. And so one would say, if you're really trying to include the types of people that you get on jurors, you need to maybe possibly expand that source list. The assignment judge oversees the process to ensure public and random selection of jurors. It's important to note that I was on jury duty in September. I had to go fill out that questionnaire that all the jurors are asked to do, that qualification questionnaire. Pre-reporting administrative process. The assignment judge or another judge or their designee will look at all excuses and deferrals. So probably during the pandemic, we changed a little bit in Monmouth what we previously did. I think in most counties, the jury manager often looks at the request for excusals and deferrals. And I had the bright idea that I wanted to look at all of those excuses, and there are hundreds of them every week. I have since delegated some of that responsibility. I do grand jury. We have 2 judges, presiding judge in civil and criminal, that share in that. And more recently, the jury manager does some of that. let's see, jurors are excused pursuant to the statute, or can be excused if you're 75 or older, you've served within 3 years, you're a caretaker, highly specialized healthcare worker, and a volunteer fighter, all pursuant to statute. Requests for deferrals are liberally granted, as well as excusals with the exception of 3-year terms. They all require substantiation. And again, when we talk about this whole idea of trying to get as many jurors into the system as you possibly can, and when you look at and have an opportunity to watch some of the jurors during jury selection, some folks ask, why does it take judge such and such 2 weeks to pick a jury for a burglary trial, and judge such and such can do it in 2 or 3 days? So I was just yapping without the PowerPoint the whole time. And I think that it comes down to some judges are a little bit more lenient with the request for excusals, as you were talking about, Judge Lisa. And some judges work and cajole and turn on the personality with the jurors to really try to encourage them to serve. Panel sizes. Panel size determinations usually involve sometimes the assignment judge, the trial judge, and jury management. So for example, if it is a murder trial, you may want to, the judge may say, I want 400 jurors. I think I'm going to need 400 jurors to get to my 16 jurors, as opposed to a simple possession or an assault may take a lot fewer. One judge may say, I only need 200 jurors. Panel size calculations. My experience in Monmouth is consistent with the data cited by the Lisa report and Dr. Rose's study, that attorneys on an average do not use all of their preemptory challenges. Even before this presentation, I had an occasion to speak to a lot of the judges. I've watched, especially during the pandemic, a lot of the jury selection to make sure it goes smoothly, and most folks don't. As a matter of fact, during the pandemic, you do all of the questions virtually, and you do the in-person part for preemptory. The preemptory part, usually it could last as quick as 10 minutes or a half an hour, where the preemptory challenges are exercised. So that part goes really fast. Of the we've had 12 criminal trials in 20 and 21 in Monmouth County. On an average, defense used an average of 11 preemptories and the prosecution 7. Examination of jurors during voir dire, as in the federal courts, New Jersey State Court judges lead the examination. Consistent with statewide data, judges in Monmouth routinely grant challenges for cause. And examination of jurors during voir dire. As Judge Lisa indicated, I think all judges across the state recognize the importance of that attorney participation. There are standard questions as well as open-ended questions for jury selection. And for cause and preemptory challenges. During our discussion, I guess it was 2 weeks ago, with Judge Massano, Mr. Kokora, and Judge Lisa, we talked about this whole idea consistent with 183 of there always being a possibility for attorneys to jump in and ask questions. And many of us agreed that attorneys rarely, if ever, do that. I had an occasion to speak to one of our judges, and it appears that she creates that type of environment with her trials where she encourages the attorneys to jump in. But when we had that discussion, I had to go back and look at the comment to the rule, which is usually where you always find the great kernels, and you learn so much for the comment to the rule. And Judge Lisa talked about this as well. That attorney participation is laid out in the statute as well as the court rules. 2B2310 talks about in the discretion of the court, parties may question a juror without the interposition of any challenge. Such an examination shall be permitted in order to disclose whether or not the juror is qualified, impartial, and without interest in the result of the action. The questioning shall be conducted in open court under the trial judge's supervision. And especially when you look at the comment to 183A, I guess you can figure out why the attorneys really don't always jump in or ask too many questions. The comment cites State versus Manley as explaining the purpose of the rule as remedying a practice where in many instances it is taken as long or longer to impanel a jury than to try the case. The impression is inescapable that the aim of counsel is no longer exclusion of unfit or impartial or biased jurors. It has become the selection of a jury as favorable to the party's point of view as indoctrination through the medium of questions on assumed facts and rules of law can accomplish. The comment further instructs that in order to accomplish the purpose of 183A, the trial court, in administering the discretionary portion thereof, must exercise considerable restraint over supplementary questioning by counsel. The basic intent is to have the voir dire conducted exclusively by or through the trial judges to the extent reasonably possible. Examination by the court will be facilitated if questions on subjects the parties or counsel desire covered are submitted in advance or at the opening of the trial. And 183F requires that the mode of attorney participation must be done in that on the record pre-trial conference. So I think that when we look at this whole issue from soup to nuts about jury selection and voir dire, it's important to note that it's really not necessarily about, as you indicated, Judge Lisa, trying to get a jury faster. I think trying to be more efficient in jury selection is really important. In my role, particularly over the last couple of years in overseeing this jury process, I probably have touched thousands, maybe 10,000 jurors during jury selection. And I touch them from the time we do orientation until that actual selection. And it is very obvious that we lose so many jurors because of the length and the process of that jury selection. You know, many folks work, their employers are hesitant to let them off for a trial that would be 4 weeks, 2 of them just being for jury selection. And I think as a group of people that are interested in this system of justice, this beautiful system of justice that we have to ask ourselves, who do we want to serve on our juries? I often say that when I try to cajole folks to serve on jury duty, I often tell them, do we want just folks that are retired? Do we just want folks that are state workers that can afford to serve on that jury? Or do we really want that beautiful cross section of our community? And if in fact we really do have to take a good look at how we select folks and be more respectful, I think, of their time.
Thank you, Judge. Mr.
We're
Pecora.
going to do a little logistical change of place. Yours is going to get us on the right track. Morning, everybody. So my goal in my 20 minutes is to put on the table for consideration by this conference and subsequently by the committee appointed by the chief, a model of jury selection that shifts significant portions of the voir dire from judges to lawyers. In other words, a model of attorney-conducted voir dire. And over the past couple decades, there's a growing body of research that has started to show that this type of model is more successful at eliciting honest and open answers from jurors, thus permitting the court and the lawyers to identify both explicit and implicit bias in the process, obviously a fundamental goal of the conference. It provides more information to judges and lawyers, both in determinations of whether motions for cause challenges should be granted, but also in terms of the lawyer's information to be used in exercising their peremptory challenges. Before I get into the nuts and bolts of how a model like this would work, I want to just make one observation. What I'm asking everyone here to do is, during the next 15 minutes, 20 minutes, look at me not as a criminal defense attorney, public defender who's been doing this for 32 years. That's scary. But rather as a trial attorney who's personally tried well in excess of 100 some odd cases, many of them murder cases, 12 capital cases to verdict prior to our enlightened state's abolition of the death penalty in 2007. And I say that because this should not be among the lawyers in the state a partisan issue. Prosecutors, defense attorneys in criminal cases, lawyers who represent plaintiffs, lawyers who represent defendants in civil cases, they should all embrace a method that gives them, as the litigants, a right to probe the beliefs of the jurors. And to the judges in the audience, I simply ask that you keep an open mind, because as the chief alluded to in his opening remarks, sometimes it's hard to change and it's hard to rethink the way we've been doing something for a long time. My presentation is built around a real case out of Kentucky. Kentucky has a model of jury selection. You're going to see how it works momentarily. I'm going to walk you through it. The trial itself is a domestic violence, kidnapping, aggravated assault case. So it's serious charges. The entire jury selection process took 2 hours and 40 minutes from beginning to end. The only thing left at the end of that 2 hours and 40 minutes is the exercise of peremptory challenges, which, as you will see, goes very quickly in a model like this. There's a full video of that, which is going to be up on the website. I encourage you to watch it to get a sense of how this looks in practice, because you can watch the entire jury selection process, as I say, in 2 hours and 40 minutes. The PowerPoint that I'm going to pick up on now has some embedded clips from the actual process. Fortunately for me, I came up here yesterday to do a test run to make sure I was up to snuff on the technology, and realized that some of the clips in a big auditorium like this are not as easily understood and heard as I had hoped. So I'm gonna have to make a few adjustments, but I think I'll be able to give you over the next few minutes an idea of how a model like this would work, keeping in mind that there are variations to it. And they generally go to the extent to which the judges ask questions preliminarily on subjects about the law, qualifications for jurors, as opposed to the questions that the attorneys primarily ask, which go to their understanding of the facts of the case and the issues they think are important. Next slide. Okay. So my whole master plan has been defeated, Judge Massano. I thought I would be able to see the PowerPoint on my screen here, but I can't. I could have stayed right where I am. So what is attorney-conducted voir dire? Well, it's important to note that it's a panel voir dire. It's not individual voir dire. You'll see how that works momentarily when we walk through the steps of the jury selection process. It's an opportunity for the parties, as opposed to the court, to probe the jurors' beliefs. And obviously, it allows attorneys to pose questions directly to the jurors. What it doesn't do is provide an opportunity for the lawyers to indoctrinate the jurors, because the judge is there as a referee to ensure that the questions are open and fair and not designed to what we would term indoctrinate the jurors. And it doesn't allow attorneys to take over the role of the judge, because, as I just said, the judge is in the courtroom overseeing the whole process and essentially acting as a referee to make sure that the kinds of questions posed by the lawyers are appropriate. Next slide. There are some myths about attorney-conducted voir dire. We're going to show you it's not necessarily a process that takes longer. In fact, there's growing evidence that it's a more efficient way of picking a jury, which, by the way, given the backlog in the courts created by the pandemic, should certainly be a priority for this conference and the committee. It's not true that the parties learn less, they learn more about jurors, because studies show that jurors are more open when talking to lawyers, as opposed to trying to give judges the quote unquote right answer, which is often what happens. All right, next slide. So to give you an idea where we're going nationally on this, New Jersey is one of only 8 states left, along with the District of Columbia, that employs essentially a judge-dominated conducted system. And the executive summary is a document that's available on the website that was prepared by an internal working group in my office, chaired by our Director of Training, Jennifer Saletti, which gives a very good background on this growing movement towards attorney-conducted voir dire and why it's something we should be considering. Next slide. So this is it, the 7 steps to pick a jury in the model used in Kentucky and many other states. And I'm going to take you through the slides to show how each one which, with pictures of the actual courtroom during this particular case in the jury selection process. The jurors come to court. We'll talk about this concept of a panel, which is a little different meaning in a system like this than what we normally think of. And then the steps during which the judge, the prosecutor, and the defense attorney question the panel. Ultimately, the motions for cause challenges by the lawyers and the exercise of peremptories. Next slide. Oops. Okay, so this is the courtroom at the beginning of the trial. And you can see it's a little different because you'll, in a moment, you'll see that this is the folks in the back of the courtroom have been summoned to jury, just like we do in all our cases when the big panel is sent to a courtroom to start a trial. The difference is you'll see these chairs set up a little differently, the jury box and then additional chairs. And that's the concept of the panel. So in Kentucky, and you can go to the next slide, by the way. Okay, so in Kentucky, there are 6 challenges for the state and 12 for the defense. So that's 18. And if, assuming the judge wants to sit 12 and 2 alternates, that's 14, that brings you to 32. So what happens at the beginning is 32 jurors are drawn from this big group in the back, and they become what I'm going to refer to as the panel. And of course, the magic number is it's not coincidence, the idea being that at the end of the voir dire process, you will have this group of 32. And that ensures that even if both sides exercise all their peremptory challenges, there will be a jury at the end of that process. And you'll see how that works in the end as we go through this. Next slide. So these are some of the ones, and I think it's probably better. The judge will then address the group of 32. And the judge will do the same thing as the judges normally do here, which is ask the other people in the courtroom to listen to the questions and note in some way if they would have answered affirmatively to the different issues. Now, in Kentucky, the judge only goes into 3 areas at the outset. First identifies the case and the charges, but then only 3 areas. Has the attorneys introduce themselves, the defendant, the names of witnesses, people who would be involved in the trial, and ask the jurors if they have a personal relationship or know any of these folks, just like we do here. And that's done by the judge. The judge then questions hardships. Now, in this particular case, there were very few hardships because the judge told the jurors that there would be a 2-day trial, the day of picking the jury and only 1 more day, because I guess it was a relatively short case. So there weren't hardships to speak of because it was such a short trial. And then the judge, and you can go to the next slide here, talks about the nature of the charges. Now, I guess let's play this clip real briefly, if we can. I know I throw you off.
Okay. Now, the type of charge, this is one that I know the parties would ask about, but it may impact a few, so I'm going to go ahead and ask it myself. The charges, again, that are alleged are unlawful imprisonment in the 1st degree, assault in the 4th degree, domestic violence, and assault, another charge of assault in the 4th degree, domestic violence. By the nature of those charges, and again, we'll address our front 32 first, is there anything about a personal history that anybody has that this might not be the trial for you because of the type of charges?
Okay, you can stop that and go to the next slide. So that's what the judge introduced, a question that we would have here typically. Now, this is one of the parts that unfortunately, I don't want to play this clip because it's very hard. We did a little test yesterday to hear the audio, but this is a juror who answered yes to that question, and he came to sidebar and he explained to the judge and the lawyers that he had a former girlfriend who, as he put it very diplomatically, had the snot beat out of her in the past, and then that his current wife was suffering from Alzheimer's degree, which he believed was caused in part by domestic abuse against her by her first husband. And that he worked in the prison in some capacity as a corrections in the Department of Corrections, and he'd seen a lot of abusers that he considered to be quote unquote scum. Needless to say, he did not make the cut. He was excused for cause, but that's how that portion of the trial is done. The judge does that segment. Now, that's where the kind of the flexibility in these systems can be built in, because it might be that there are additional questions about the law that would be more appropriate for the judge. Things about the principles of law, presumption of innocence, those kinds of questions might be built in so that the judge does a bit more than in Kentucky, where the judge really only covers those three areas. All right, next slide. All right, again, so now you see this is the prosecutor. He is now standing in front and he's addressing the panel of 32. And in this clip, which was very hard to hear, and it might be, but I don't want to have something that doesn't a glitch technologically. But what he does here is he asks the jurors questions about memory and the kinds of things that would cause someone's memory to fail. Now, presumably, the prosecutor knows his case, and there's some issue with his witnesses. Perhaps there's an issue that one of the witnesses had forgotten something in the past or changed her story. So he asks jurors all to the panel. He says, basically, what kinds of things do you believe cause memory loss? One juror raised hand, says old age. He doesn't pursue that. I don't think that applied to the case. Somebody else says head injury. When another juror raised hand, says stress and traumatic experiences. The prosecutor then follows up with some questions about that. Well, tell me about that, right? Presumably his witness was a victim of domestic violence and was subjected to stress and or trauma or both. So this allows him to talk to the jurors by following up with questions, maybe saying, anybody else agree with that? Are any of you that disagree with the idea that stress can cause failure of memory? And it just gives the lawyer a chance to ask questions and give the jurors a chance to respond. Next slide. This is an important piece. What happens here is the prosecutor starts to ask the prospective jurors a question about self-defense, and is trying to frame a question about whether the jurors believe that the use of self-defense is sort of an unlimited one, or should it be limited to the proportion of the force used against you? And this is probably because the defendant has some kind of self-defense claim, and the prosecutor's probably of the view that that use of force by the defendant was in excess of that threatened against him, if that's the case. But again, this is one of the benefits. The lawyers know the facts of the case in the way that a judge doesn't. The prosecutor, go to the next slide. Okay, so they go to sidebar. The defense attorney objects that the prosecutor is going into areas of the law. And the judge says, I think that's okay because he's stating the law correctly. But then if we could play this clip, I know I'm throwing you off, Tom, but if you could play this clip, this is what happens when the prosecutor goes back to
We'll interject very quickly. The court will instruct the jury that here's the case on what the law is on all the issues. And if self-defense is one of those, you'll be instructed on what the law actually is. This is just a discussion between you and the attorneys about the subject. So I just don't want anyone to think that an expressed opinion is accurate regarding the law. You'll be instructed on the law at the appropriate time.
Okay, so you can see what the judge is doing. The judge is clarifying for the jurors that the lawyers are going to be given some leeway in discussing the law of self-defense, but that ultimately it's the judge who will define what the law is. And we know that's how it works in practice. But I think that's important because one of the myths about attorney-conducted voir dire is that the judge loses control of the process. And this is an example of how the judge maintains that control to make sure that the questions stay within proper bounds. Okay, next slide, please. So now in this case, and I should tell you, there's no time limits in Kentucky put on the lawyers. It's not like they say, you get 30 minutes to talk to the panel. Instead, in this case, it happened to be 30 minutes. That's how long the prosecutor addressed the jurors and asked questions. And you can see in that 30 minutes, the prosecutor, who's a very experienced attorney and struck me as really having a good sense of this, covered all these areas, all of which you can see are likely specific to his concerns about the jurors' beliefs in a domestic violence case where there might be a self-defense claim by the defendant. Even asking questions about whether they had experience with the police department that had investigated the case. And as you can see, a number of questions about domestic violence and self-defense. That's 30 minutes. All right, next slide. Okay, so the defense attorney gets her opportunity to address the panel. There's one portion here which is probably is an example of how the lawyer's knowledge of the facts of the case informs their question. This is a segment where she asked the jurors questions about cell phone use by their teenage children and punishment for taking the cell phone away and how kids react if mom or dad takes the cell phone away. And I first watched this and I'm thinking, I don't really know what this is, but presumably, as it turns out, there's some issue in the case where one of the witnesses that the defense is going to claim is not being truthful was a disgruntled teenager who had his or her cell phone taken away as discipline by mom or dad. And the questions were designed to go to that issue, which the defense lawyer knew was in the case and which obviously a judge would not know. Next slide. All right, so this is really cutting to the core of the conference and the goal of this whole process. I recommend highly a very good article by Judge Mark Bennett, a federal district court judge out of Iowa. He wrote a very compelling argument. It should be up on the website. We submitted it. That talks about the failure of Judge voir dire relative to attorney conducted voir dire and sort of the relationship between a shift to an attorney voir dire method and how that is, in his opinion, absolutely a prerequisite to any discussion about reducing or eliminating peremptory challenges. It's very compelling, and some of what we put a few quotes on this slide to give you a sense. Let's go to the next slide. All right, this part I'm going to ask you to play it a second time. This is the attorney, the defense attorney, asking the jurors questions specific to race. Could you play that, please?
All right, now I have to ask you some questions that might be somewhat uncomfortable, and I just ask that all of you be honest about them. But obviously, we want you all to be honest and give your open and honest answers. And I keep saying the same thing. I'm sorry. Is there anyone that believes that African American people are more prone to violence? Yes. I'm sorry?
Yes.
Yes? Okay. Can you expand on that?
Yes. Their nature.
Their nature? Okay, so it's something in their genes? Is that what you're trying to say? Okay. All right. Does anyone else agree with, let's see, Mr. Welch? Is that your name? Anyone else agree with Mr. Welch?
No, but I have something to say. I believe they're targeted more.
You believe they're targeted more? What do you mean when you say targeted?
They are. I mean, look at the unprecedented numbers in prison today.
And what are you getting at? If you could explain a little bit more.
Very simply, I mean, they're racially profiled.
Okay. So you think there's more African American folks in prison than other races, or at least as compared to Caucasians?
The numbers speak to it.
Okay. Does anyone else agree with, I'm sorry, I forgot your name.
Robert Park.
Okay, Mr. Park. Does anyone else agree with Mr. Park or made a similar observation?
I was in an army, combat, in an army, about 35% is black. In combat arms, about 70% is black.
Okay.
Okay?
Yes,
So
sir.
I was with a lot of African Americans in the United States Army. So
Okay.
I got a good perspective in 21 years.
I understand.
And this is what I came up with.
Okay.
And this is what I've seen on the outside.
Did you ever see your fellow soldiers that were African American get accused of something wrongfully?
Absolutely.
Okay.
Okay, I should stop
Anyone
that
else
one,
have any thoughts on-
and move on to the next slide real quick. All right, so the point is, in a way that judges don't do in this state, and I know from my own experience, I've met with resistance from judges going back to the days of capital jury selection, when these kinds of questions that are important if we're going to detect implicit and explicit racial biases in our jury pool. Questions like, do you believe that Black people are more likely to commit crimes of violence? She framed it in terms of propensity to act violently. And sure enough, one of the jurors raised his hand and said, yes, it's in their nature, it's in their genes. So that bias is not often detected in our trials because those kinds of questions don't get asked, and yet they go to the core of what we're trying to do here if we're going to uncover bias in our jury pool. The defense attorney took 30 minutes. These are all the areas that she was able to cover. So you can see and the 30 minutes was just coincidence that she took the same amount of time as the prosecutor. And you can tell from this that she was able to ask this panel of jurors a lot of information about how they feel on issues pertinent to the case. Next slide, we're getting to the end here. So what happens and this can be done in a couple different ways. It could be done after the prosecutor does his voir dire, they could go to sidebar and the lawyers on either side could make motions to challenge jurors for cause. It could be done at the end after both lawyers have had an opportunity to question the panel of 32. There's different ways you could work that. But the point is, once that voir dire process is over, the attorneys are free to make motions to challenge jurors for cause. And the judge will rule on them accordingly. If the judge excuses jurors, why don't you go to the next slide? For cause of the 32, then let's say 4 of the 32 are excused based on motions for cause challenges. Then 4 more people are drawn from the big audience in the back to fill those seats. They're asked if they would have had any comments or answers to any of the questions that the lawyers posed. They're given that opportunity. The lawyers are given a brief opportunity to speak to them, but that process then concludes. And what's left, of course, are peremptory challenges. And in different states, there's a couple ways that's done. Some are done alternating the way we have always done it here. In other states, the lawyers would literally go and write down, let's say I had in Kentucky 12 challenges and I'm the defense attorney, I would just write the 12 jurors that I want to challenge with peremptory challenges on a piece of paper. Prosecutor would put his or her 6, and then there would be 14 people left to start the trial. And if the lawyers overlapped, and let's say they both wanted to challenge the same juror, so that you had 15 or 16 or more, then random drawing eliminates the number that gets it down to 14. And they're there, the 14 remaining jurors. So let me just real quick in conclusion, there are variations on this model. I get that. The extent of jury questioning, on the types of questions that would be permissible by lawyers. But I think in the end, if we're serious about this reform and improvement in our jury selection process, if we really are, I think as a system here in New Jersey, we need to embrace an expanded model of attorney-conducted voir dire and use that as one way in tandem with other issues like reconsidering the standards to be applied to motions and so forth. There's other issues coming up over the next 2 days to make the system fair and better and help us detect bias among prospective jurors. So thank you, Judge.
Thank you. I obviously failed the moderator course at law school because I let everyone speak too long. So we have time for one question, perhaps from the audience. If you could come up to the microphone and ask the question. The next panel is due to start in just a couple of minutes, but we'll be here for the rest of the night. So you can ask us questions if you want. Identify yourself just for those who.
Thank you to all the panelists. But Justice, you're so most familiar with that process. Would it be true then if we were using that model, that the number of peremptories really would not impact the timing significantly.
It wouldn't necessarily impact the timing, but by definition, what it would do is it would expand the number in the panel, right? In this case, the parties had 18 peremptory challenges, so that made 32 people in the panel. If the number was higher, it would mean more in that panel, right? Which I guess that might not necessarily make it take longer, but I guess if that meant more jurors were excused for cause, right, and more people had to come in, I guess it would. I don't know that the answer to that is a definitive yes or no, but
Instead of 20, if we had 20 and 12 and 14 jurors were going to be seated, you would have 32-46 as opposed to.
Right, so when we did capital
that would put
cases,
the panel.
we used to go with a struck jury system where the judge would try to get a pool of 48 because it was 12 jurors, 4 alternates, and 32 challenges. So it'd be 48 instead of 32.
Right, but once you got down to that last part where people were going to use their peremptories, you said it
Oh, I mean,
went.
the exercise of peremptories wouldn't take any long. In fact, it's really, that's just pro forma in the sense that the lawyers make a list or they come in and they know. That's when we try capital cases. You come to court on the last day, you'd know exactly which jurors you were going to use your peremptory challenges. So it went very quickly. You're right about that.
Thank you.
Okay, thank you. We ran over a little bit, but we're ready for the next session.